She gave up the right to call herself a mother when she chose silence over her own child. That's what my father said. Not in our kitchen, not at Thanksgiving dinner, in a courtroom, under oath, with my 12-year-old daughter sitting 6 rows behind him. I didn't flinch. I didn't look at him. I adjusted the small gray pin on my lapel and waited. They don't know that yet. My name is Seren Whitley. I'm 43 years old. And up until 6 weeks ago, I was running an intelligence network on the other side of the world, under a name that doesn't belong to me, in a country I will never be permitted to name. Now I'm sitting in a family courtroom in Millhaven, Tennessee, listening to my own father describe me as an unfit mother. If you've ever been judged by people who don't have a fraction of the facts, hit that like button and subscribe. I learned the hard way that in my family, my silence was never read as strength, only proof that I had something to hide. The morning I arrived in Millhaven, the October air tasted the way it always had. Copper and wood smoke, and something earthy beneath it. Like the ground remembered rain, even when the sky had been dry for weeks. The leaves along Route 9 had turned that brittle shade of gold that snaps when you step on it. The kind of gold that looks beautiful from a distance and crumbles the second you touch it. No one was waiting. No car in the courthouse lot with a familiar face behind the wheel. No text from my mother. No call from my sister. Just a rented sedan, a garment bag hanging from the backseat hook, and the weight of 20 years of federal service pressing against the inside of my chest like a hand that had never learned to let go. I parked across from Whitley's Hardware and Feed. The sign hadn't changed. Same green lettering my father had painted the summer I turned 9. Same American flag bolted to the awning bracket. Same bench out front where the men who had nothing better to do on a Tuesday morning sat and talked about everyone else's business as though it were civic duty. The flag outside the council building was at full staff. I noticed that the way I notice everything. Quickly. Completely. Without showing it. I didn't go inside the hardware store. I hadn't been inside in 4 years. My father's name was stenciled on the glass in the same font he'd used on the council letterhead, on the church bulletin sponsorship line, on the guardianship petition he'd filed 6 weeks ago with the Millhaven County Family Court. Harlan Dean Whitley, Chairman, Township Council. Owner, Whitley's Hardware and Feed. Father of the Year, if you asked anyone on Main Street. That was the story he had built. Carefully. Over 8 years. Brick by brick. Conversation by conversation. Sunday by Sunday. And the thing about a story told slowly enough, by a man trusted deeply enough, in a town small enough, is that it stops being a story. It becomes the truth. Not because it's true, because no one is left to contradict it. They hadn't just forgotten me. They'd rewritten me. Growing up in the Whitley household meant earning affection like rent. My father measured worth the way he measured lumber. Visible. Quantifiable. Something he could hold in his hands and show to the next customer. Claire worked the register. Claire sang in the church choir. Claire married a boy from 2 counties over and had her reception in the VFW hall with 200 guests and a 3-tier cake my father paid for, with a check he made sure everyone saw him write. I was the other one, the intense child. Too curious, too quiet, too precise. I asked questions that didn't have hardware store answers. I read books that didn't come from the church library. When I was 23, I left Millhaven with a suitcase and a federal ID badge, and my father told the neighbors I'd taken a government desk job. procurement compliance, mostly travel. That was the cover. Not the one I chose. The one that kept people alive. Some clients prefer discretion. Some operations require it. And some secrets aren't kept out of shame. They're kept because a single misplaced word in a small-town hardware store could put a man in a shallow grave 6,000 miles away. But my father never saw it that way. To Harlan, silence was guilt. Absence was abandonment. And a daughter who couldn't explain where she'd been for 7 months was a daughter who had chosen to disappear. He wasn't entirely wrong about the disappearing. That was the tragedy of it. I had disappeared. Into cover names and borrowed passports and hotel rooms in cities where the electricity cut out at midnight, and the only light was the blue glow of an encrypted terminal. I had disappeared into 11 countries and 16 years of continuous service, and an operational record that would never hang on any wall, in any frame, in any room my father would ever enter. I recruited assets in places where recruitment meant risking execution. I ran networks that produced intelligence briefings, read by people whose names I knew only by their office numbers. I fed reporting into a counter-proliferation division that used it, over 6 years, to dismantle a $230 million illicit arms pipeline that was moving warheads across borders like furniture. And my father told the church congregation I did paperwork. The morning of the hearing, I sat in the courthouse parking lot for 11 minutes. I know because I counted. In the field, you count everything. Seconds between radio checks, steps between doorways, breaths between decisions that will either keep your asset alive or get them killed. 11 minutes in a parked sedan outside a county courthouse should have felt like nothing. It felt like the longest operational pause of my career. I opened the garment bag. Black dress. Simple. Sleeves to the wrist. The silver bracelet I usually wore over the scar on my left wrist was in my pocket. I left it there. Today the scar was visible. Thin. Pale. Old. Origin classified. But it was mine, and I was done covering things that belonged to me. I pinned the gray enamel compass rose to my lapel. To anyone in that courtroom, it would look like jewelry. A coat button someone had repurposed. Nothing worth a second glance. But it wasn't jewelry. It was a citation. And before the day was over, someone in that courtroom would recognize it for exactly what it was. Not yet. The courtroom was smaller than I expected. Wood-paneled walls the color of weak coffee, a water-stained ceiling tile above the witness box, an American flag in a brass stand that leaned slightly to the left, as though even the flag was tired of standing at attention in this room. My father was already seated. Front row, petitioner's side, gray suit, blue tie. The tie he wore to council meetings. He had his hands clasped on his lap the way men do when they want to appear patient, but are actually performing patience for an audience. Claire sat beside him. Same posture. Same folded hands. She had driven him. She had always driven him. My mother sat 3 rows back, alone, her purse in her lap, her eyes on the middle distance. Diane Whitley had spent 46 years married to a man who spoke loudly enough for both of them. She had never spoken against me, but she had never spoken loudly enough in my defense either. Silence, in the Whitley family, was inherited. I got it from her. The difference was that I had learned to weaponize mine. She had only learned to endure hers. Mara was in the gallery, row 6, beside Midge Thornton, who had one hand resting on Mara's knee, the way you rest a hand on something precious that might break. Mara's hair was pulled back, Her eyes were steady. She looked at me once when I entered, and in that look was something I recognized from 20 years of reading people in rooms where a misread could kill you. She wasn't scared. She was watching. She was cataloging. She had inherited my stillness, and right now that stillness was the only armor she had. I sat down at the respondent's table, folded my hands. The scar on my left wrist caught the fluorescent light. Harlan's attorney stood, a man named Leland Porter, mid-50s, local practice, the kind of attorney who handled property disputes and DUI pleas and had never, in his entire career, encountered a sealed federal affidavit. He straightened his jacket. He opened his folder. And then he began. Your Honor, my client, Mr. Harlan Whitley, brings this emergency petition on behalf of his granddaughter, Mara Whitley, age 12. The child's mother, Seren Whitley, has been absent from the child's life for a period of 7 consecutive months. During that time, she provided no address, no phone number, no verifiable employer, no explanation. He paused. He looked at me the way people look at a defendant they've already convicted in the parking lot. A child needs a parent who is present, not a postcard and a wire transfer. My father nodded. Slowly. The nod of a man who had rehearsed this moment in his living room. Whatever Ms. Whitley does for the federal government, Porter continued, if she is, in fact, still employed by the federal government, it does not exempt her from the fundamental obligations of parenthood. We have community testimony. We have school attendance records showing the child has been in the primary care of her maternal grandmother for the better part of 3 years. We have a church elder who has known Mr. Whitley for 40 years and can attest to his character, his stability, and his commitment to this child. He placed a document on the judge's bench, then another, then a third. Your Honor, we respectfully request emergency guardianship be granted to Harlan Dean Whitley effective immediately. The room was quiet. Even the ceiling fan seemed to slow. My father turned in his seat. He looked at me. Not with anger, not with cruelty, with the steady, righteous certainty of a man who believed he was saving a child from her own mother. And that was worse, because cruelty you can fight. Certainty you cannot. Judge Patricia Rourke looked up from the documents. 31 years on the bench. Eyes that had seen every variety of custody performance. She looked at me over the rim of her reading glasses. Ms. Whitley, you've heard the petition. Do you have representation present? I didn't have an attorney at that table. What I had was something else entirely. Something that was, at that very moment, being carried down the courthouse hallway in a sealed envelope by a woman in a navy suit whose credentials would make Leland Porter's bar card look like a library card. But the envelope hadn't arrived yet. So I sat still. I folded my hands, and I answered. I'm representing myself, Your Honor. My father exhaled, the exhale of a man who thought he'd already won. That was the last time he exhaled like that. The judge turned a page in Porter's filing, then another. She read the way I read rooms, quickly, completely, without showing what she found. Ms. Whitley, she said, the petitioner alleges 7 months of continuous absence, no verifiable address, no employer documentation, no direct communication with your daughter during that period. She set the page down. Before I hear testimony, I want to give you the opportunity to respond to the factual basis of this petition. I placed both hands flat on the table. The scar on my left wrist was 2 feet from the judge's line of sight. I didn't cover it. I didn't move it. The petitioner's facts are correct, Your Honor. I was absent for 7 months. I was not reachable by personal phone. I did not provide an address. A murmur moved through the gallery, the way wind moves through dry grass. Low. Fast. Gone before you can point to where it started. My father leaned forward. Claire placed her hand on his arm, not to restrain him, to anchor herself. Porter stood again. Your Honor, the respondent has just confirmed the core of our petition. 7 months. No contact. No. I heard her, Mr. Porter. Judge Rourke didn't look at him. She was looking at me. Ms. Whitley, can you tell this court where you were during those 7 months? The thing about silence is that it isn't always passive. Sometimes silence is the sharpest answer. I'm not permitted to say, Your Honor. I never have been. Not permitted by whom? By the terms of my employment and the agreements I signed upon entering service. Porter opened his hands toward the judge, a gesture meant to say, You see. Your Honor, this is precisely the pattern we've documented. Vague references to unnamed employment. No records. No. Mr. Porter. The judge raised one finger. One. It was enough. I asked the respondent a question. I'd like to hear her answer without editorial. Porter sat. His chair scraped the floor. The sound was louder than it should have been in that room. Judge Rourke turned back to me. Ms. Whitley, you say you're bound by employment agreements. Can you tell me the name of your employer? That's classified, Your Honor. My father made a sound. Not a word. A sound. The kind of sound a man makes when he hears something he has been waiting to hear. Something that confirms what he already believes. It came from deep in his chest. Half exhale, half dismissal, and it carried across that courtroom like a verdict. Claire looked down at her lap. My mother's hands tightened around her purse strap. Classified. Porter said the word like it tasted artificial. He stood again. Your Honor, with respect. Anyone can say that word. I could say my breakfast is classified. That doesn't make it true. There is no documentation before this court. No W-2. No employment letter. No, I'm aware of what's not before me, Mr. Porter. Then Your Honor must agree that absent any verifiable proof of this alleged classified employment, the respondent is simply a mother who disappeared for 7 months and left her 12-year-old daughter in the care of an aging grandmother. He turned to the gallery, to Harlan's side, to the church elder in the second row whose affidavit was already in the file, to Claire, whose chin lifted when Porter's gaze found her. We're not asking for anything extraordinary, he said. We're asking for a child to have a stable home, a present guardian, a family that shows up. My father nodded again, the same rehearsed nod, and this time, 3 people in the gallery nodded with him. Denial, I would learn, was their specialty, not the denial of what I'd done. The denial that what I'd done could possibly matter more than what they could see. Judge Rourke removed her glasses. She set them on the bench. She looked at me for 4 full seconds, and in those 4 seconds, I understood that she was doing her own assessment, not of the petition, of me. Ms. Whitley, I have a duty to this child. If you cannot provide this court with any documentation supporting your claim of classified federal employment, I will have very limited options. I reached for the pin on my lapel, not to remove it, to adjust it. The way I always did when the pressure in a room shifted and the operational variables changed faster than the plan accounted for. The gray enamel compass rose, caught the overhead light. For the smallest fraction of a second, the courtroom fluorescence turned it from dull metal into something that looked almost like it was signaling. Leland Porter glanced at it, His eyes passed over it the way eyes pass over a brooch at a church luncheon. Ordinary. Decorative. Meaningless. My father didn't even notice. He was watching the judge. Claire saw it. She looked at the pin the way she'd looked at everything about me for 30 years. With mild confusion. With the quiet certainty that whatever it wasn't important. But in the back of the courtroom, the door had opened. I didn't turn. I didn't need to. 20 years of operational awareness meant I knew the weight of that door by the sound of its hinges, and I knew from the cadence of the footsteps, 2 sets, measured, deliberate, neither hurried nor slow, that whoever had entered was not from Millhaven. Judge Rourke's eyes lifted past me, past Porter, past the gallery, to the back of the room. A woman in a navy suit walked up the center aisle. She carried a leather folio in her left hand. Her credentials were clipped to her jacket pocket. She did not introduce herself to the gallery. She did not look at Harlan. She did not look at Claire or my mother or the church elder in row 2. She looked at my pin, and she did not look away quickly enough. I saw the recognition, the half-second pause, the way her posture adjusted, imperceptibly to anyone who hadn't spent 16 years reading the body language of people whose lives depended on not being read. She knew what the compass rose meant. She knew what it cost. And she knew that the woman wearing it in a family courtroom in rural Tennessee was not someone who did procurement compliance. She approached the bench. "Your Honor, my name is Catherine Beckett. I'm with the Office of General Counsel, Central Intelligence Agency." The room changed. It didn't change the way rooms change in movies. No gasps, no dramatic music. It changed the way rooms change in real life. The air compressed. The silence thickened. Every person in that gallery shifted from participant to witness without understanding the transition. Porter was standing. I don't think he knew he was standing. "Your Honor, I wasn't informed of any." "Mr. Porter, sit down." He sat. Catherine Beckett placed the leather folio on the bench. "Your Honor, I am delivering a sealed affidavit executed under the authority of the Deputy Director for Operations, Central Intelligence Agency. This document is classified at the TS/SCI level with Special Access Program restrictions. It is provided to the court under provisions of the National Security Act and may be reviewed only by the presiding judge." She opened the folio. Inside was a single sealed envelope, cream-colored, heavy stock, the kind of envelope that carries the weight of an institution behind every fiber of its paper. The affidavit addresses the employment status, operational record, and parental fitness of the respondent, Seren Elaine Whitley. It has been prepared at the respondent's request through proper channels and approved for limited judicial review. Judge Rourke took the envelope. She held it for a moment, feeling the weight. Then she broke the seal. The room was silent. Not quiet. Silent. The difference between quiet and silent is the difference between a held breath and no breath at all. She read. Her face didn't change. Her posture didn't shift. But her eyes stopped moving halfway through the first page, and when they resumed, they moved more slowly, more carefully. The way a person reads when they realize they are holding something that rearranges everything they assumed about the case in front of them. She turned to the second page, then the third. On the fourth page, she stopped. She placed the document face down on the bench. She looked up, not at me, not at Porter, at the gallery. "Clear the gallery." Harlan's attorney blinked. "Your Honor?" I said, "Clear the gallery." "Bailiff, Remove all non-essential parties from this courtroom. The petitioner, the respondent, and counsel may remain. All spectators, witnesses, and family members not party to this petition will exit immediately. The bailiff moved. Midge Thornton squeezed Mara's hand. I saw it from the corner of my eye. The squeeze of someone who didn't understand what was happening, but understood it was bigger than a custody hearing. My mother stood. She looked at me as she moved toward the aisle. Not with accusation, not with understanding, with something older than both. Something that lived in the space between a mother who had never asked questions and a daughter who had never been able to answer them. Claire stood. And there it was. The face I had been waiting for. My sister's face as the judge closed the courtroom. Not anger. Not confusion. Fear. The specific fear of a person who has believed one story for so long that the arrival of a second story feels like the ground shifting beneath their feet. She looked at me. I held her gaze. I didn't blink. The gallery emptied. The door closed. The bailiff stood beside it like a sentry. Harlan remained in his seat. His hands were still clasped, but the knuckles had gone white. The patient, rehearsed posture was exactly the same, but the man inside it had changed. He didn't know what was in that envelope. He didn't know what the woman in the navy suit had delivered, but he knew, the way all men who have built stories eventually know, that something had arrived that his story could not absorb. Judge Rourke placed her glasses back on. She looked at the sealed pages. Then she looked at me. Ms. Whitley. Yes, Your Honor. The affidavit before me is executed by the Deputy Director for Operations, Central Intelligence Agency. It confirms your continuous employment in the clandestine service for a period of 16 years. It confirms your classification status. It references operational activity consistent with the 7-month absence cited in this petition. Porter's mouth opened, then closed, then opened again. No sound came out. It further states, the judge continued, and now her voice had shifted into something I had heard only a few times in my life. The voice of a person who has just learned that the room they are standing in is smaller than the world outside it. That your absences from this jurisdiction have been conducted under direct authority and in service to national security objectives of the United States. It describes your operational record in terms I am not permitted to repeat in this proceeding, or in any proceeding, or in any record that will leave this bench. She set the document down. It also states, and I will quote this single line because it is the only line I am authorized to convey, that the Deputy Director for Operations personally attests to the respondent's fitness, dedication, and sacrifice as both an officer of the Central Intelligence Agency and a parent. My father's hands unclenched, not deliberately. They simply fell open, the way hands fall open when the body understands something the mind hasn't caught up to yet. Catherine Beckett stood at the side of the bench, still, professional, her eyes on the middle distance. But when the judge read that last line, Beckett's chin dipped, a fraction of an inch, the ghost of a nod that wasn't protocol and wasn't performance. It was recognition. The same recognition the pin had triggered. The silent acknowledgement of one officer who knew what another officer had carried. Mr. Porter, the judge said, is there anything in your filing that accounts for the possibility that your client's daughter is a senior intelligence officer of the United States government whose absences are a function of classified national service? Porter looked at Harlan. Harlan looked at Porter. The exchange lasted less than 2 seconds. It contained the entire collapse of a narrative that had taken 8 years to build. Your Honor, we were not. My client was not aware. I asked a specific question, Mr. Porter. No, Your Honor. There is nothing in our filing that accounts for that. No, there isn't. Judge Rourke leaned forward. The bench creaked. Even the bench seemed to feel the weight of what came next. The petition for emergency guardianship is dismissed, with prejudice. My father's spine straightened. Not in defiance, in shock. The involuntary reflex of a body receiving a blow it didn't see coming. His shoulders drew back, his jaw tightened, and then, slowly, like a structure losing its central support, his posture began to fold. His hands found the edge of the pew in front of him. He gripped it. His knuckles went from white to gray. Furthermore, the judge continued, I am entering a standing order prohibiting the petitioner from filing any future custody or guardianship motions regarding the minor child Mara Whitley without prior judicial approval from this bench. Any attempt to circumvent this order will be treated as contempt. Harlan opened his mouth. Mr. Whitley. The judge's voice was not loud. It did not need to be. I strongly advise you not to speak right now. His mouth closed. Catherine Beckett stepped forward. She collected the sealed affidavit from the bench. She placed it back in the leather folio. She closed the folio with a sound that was barely audible, the soft press of leather against leather. And yet it was the loudest thing in that courtroom. She turned toward the door, and as she passed my table, she paused. Half a step, less than a second. Her eyes found the gray compass rose on my lapel, and this time, she didn't look away. Ma'am, she said, quiet, precise, the single syllable carrying the full weight of an institution that could not say what it meant in open court. Then she walked out. Harlan Whitley sat in the front row of a courtroom that no longer belonged to him. His suit was the same. His tie was the same. His hands were still gripping the pew. But the man inside the suit had come apart in a way that no one on Main Street would ever see. Because it happened in a closed courtroom, in a sealed proceeding, in a silence that would never be broken. The judge looked at me one final time. Her expression was careful, controlled. But behind the judicial mask, I saw something I had not expected. Not pity, not admiration. Gratitude. The quiet gratitude of a woman who had just learned that someone had been doing something immeasurably difficult, for a very long time, without anyone knowing. Ms. Whitley, she said, you're free to go. I adjusted the pin on my lapel. I placed both hands on the table, and I stood. Not quickly, not slowly. The way you stand when the operational objective has been met, and the only thing left is extraction. Controlled. Measured. Without performance. Harlan hadn't moved. His hands were still wrapped around the pew in front of him, and his knuckles had passed through white into something closer to the color of the wood itself, as though his body was trying to become part of the furniture, part of the room, anything other than a man sitting alone on the wrong side of a dismissed petition. Porter was gathering his papers. His hands were not steady. The folders that had seemed so authoritative 90 minutes ago, the school attendance records, the church elder's character affidavit, the carefully arranged timeline of my absences, were now just paper. He stacked them the way a man stacks debris after a storm, mechanically, without looking at what he was holding. I walked toward the aisle. My father's eyes followed me. I felt them the way I had felt surveillance in the field, not as a threat, as a presence. a weight on the back of my neck that carried information if I chose to read it. I chose not to, but he spoke. His voice cracked on the first word and recovered on the second. The way a man's voice cracks when the script he rehearsed no longer matches the scene he's in. Seren. I stopped, not because he had authority, not because I owed him a response. I stopped because I had spent 20 years stopping when people spoke my name in rooms where stopping was the difference between an asset's survival and an asset's death. The reflex was professional. The pause was not for him. You could have told us. His voice was low, stripped. The council chairman cadence was gone. The hardware store authority was gone. What was left was a 71-year-old man who had just discovered that the story he had been telling for 8 years had a foundation made of air. You could have said something. Anything. One word. I would have understood. I turned. Slowly. I looked at my father the way I had looked at compromised contacts in the field, without anger, without blame, with the clear, unblinking assessment of someone who needed to determine whether the person in front of them was a threat, an asset, or neither. He was neither. You didn't want the truth, Harlan. You wanted a confession. His mouth opened. Nothing came out. His jaw worked once, twice. The mechanism of speech without the fuel behind it. I gave you 16 years of silence, I said, and you built a prosecution out of it. You took every absence, every missed phone call, every holiday I couldn't explain, and you arranged them into evidence. Not because you were worried about Mara, because you were embarrassed by me. That's not. You told the church I abandoned my daughter. You told the council I was unreliable. You told Claire I had psychological problems. I held his gaze. My voice didn't rise. It didn't need to. You didn't build a custody case. You built a reputation, and you used your granddaughter as the permit. Harlan swallowed. His grip on the pew loosened. His fingers left pale impressions on the wood. I didn't know, he said. You didn't ask. 3 words. They landed in that courtroom the way ordnance lands in a cleared zone, without resistance, without echo, just impact, and then silence. I turned back toward the aisle. I walked to the door. The bailiff opened it without being asked. The hallway was empty. Catherine Beckett was gone. The leather folio, the sealed affidavit, the institutional weight of the deputy director for operations, all of it had already been carried out of the building and back into the world where it belonged. The world that operated beneath the one my father could see. The world where my name wasn't Seren Whitley. Where my name was Foxhound Actual. Where my silence wasn't absence. It was protocol. Mara was sitting on a wooden bench in the corridor, alone. Her hands were folded in her lap, the way mine had been folded at the respondent's table. She had her mother's posture, her mother's stillness, her mother's way of watching a room without letting the room watch her back. Midge Thornton was standing 6 feet away, pretending to read a bulletin board about jury duty obligations, giving us space without leaving. I sat down beside my daughter. I didn't touch her. Not yet. I let the air between us settle the way air settles between 2 people who have been apart long enough that closeness needs to be rebuilt, inch by inch. Is it done? Mara asked. Her voice was quiet, steady. 12 years old and already fluent in the language of waiting for things to end. It's done. She nodded. One nod. Then she reached into the pocket of her jacket and pulled out a folded piece of paper, lined notebook paper, creased into thirds the way letters are creased when they've been carried for a long time. She held it on her lap. I wrote you a letter. she said. While you were gone, I didn't have an address. I looked at the letter. I didn't take it. Not because I didn't want it, because I knew if I touched it right then, something inside me would shift in a way I couldn't control. And I wasn't ready. Not in a courthouse hallway. Not 6 feet from the room where my father had tried to take her from me. I'll read it tonight, I said. She nodded again. Then she leaned into my shoulder. Not dramatically. Not the way children lean into parents in stories meant to make audiences cry. She leaned the way a person leans into a wall that has always been there. Quietly, with the full weight of trust. I put my arm around her, the scar on my left wrist pressed against the sleeve of her jacket. We sat there for 3 minutes. I counted. Judge Rourke called Harlan into her chambers 20 minutes after the courtroom emptied. I know this because James Aldridge told me 4 days later, in a phone call that lasted less than 6 minutes. He had heard it from Porter, who had heard it from the judge's clerk, who had been asked to leave the room before the judge spoke. What the judge said to my father in that room was never entered into any record. There is no transcript. There is no filing. But James told me the substance of it, and the substance was this. Judge Rourke informed Harlan that the sealed affidavit he had forced into existence through his petition contained operational details that, had they been disclosed in open court, would have constituted a potential breach of national security. She told him that the CIA General Counsel's office had flagged his petition not merely as a custody matter, but as a potential vector for the exposure of classified intelligence activity. She told him that his attorney's public statements in the courtroom about the absence of verifiable employment had come within one procedural step of triggering a federal review. She told him that his actions bordered on obstruction of national security, and that the only reason he was not facing a referral to the United States Attorney's Office was that the agency had determined the exposure risk was contained. She told him not to speak about the sealed proceeding to anyone. Not Claire, not Diane, not the church elder, not the men on the bench outside the hardware store. She told him that if he violated that instruction, the containment assessment would change. James said Porter called it the worst 15 minutes of his legal career. Harlan walked out of the judge's chambers at 4:17 in the afternoon. Claire was waiting in the parking lot. She said he didn't speak during the drive home. She said he went into the back office of the hardware store and closed the door. She said the light stayed on until midnight. He did not attend the next township council meeting. He did not attend the one after that. By December, he had submitted a letter of resignation as chairman. The letter cited personal reasons. No one on the council pressed him. In a town the size of Millhaven, men resign from things quietly, and other men let them, because everyone knows that the quiet resignation is louder than any explanation. Claire called me once, 3 weeks after the hearing. She didn't apologize. She asked me if what the judge said was true. I told her I wasn't permitted to say. She was quiet for a long time. Then she said, "I should have asked you. Years ago. I should have asked." She was right. She should have. I didn't tell her that. I didn't need to. The silence said it. My mother sent a card. Not a letter. A card. The kind with flowers on the front and a blank interior. She had written 4 words inside. "I'm proud of you. No conditions. No advice. No explanation of why she had never said it before. Just that." I kept the card. I put it in the same drawer where I keep my operational commendations. It belongs there. 4 months after the hearing, I met with the CIA's Employee Support Division. I brought a proposal. a child care trust fund for single parents serving in clandestine operations, officers whose cover obligations prevented them from explaining their absences to family courts, school administrators, or custody evaluators, officers whose children grew up keeping shoeboxes full of unsent letters because there was no address to send them to. I seeded the trust with $85,000 from my own savings. It wasn't a fortune. It was 16 years of government pay, carefully managed by a woman who had never had time to spend it on anything but the mission. The deputy director's office approved the trust within 6 weeks. Owen Castellan signed the authorization personally. His signature was the only one on the page. It was enough. The trust was named. Not after me, not after any officer, after the provision it served, but inside the file, on a single line of the founding document, there was a designation: Foxhound Actual, originating sponsor. It wasn't a medal. It wasn't a ceremony. It was a line in a classified document that no one would read unless they needed to, which is exactly where it belonged. 6 months after the hearing, I sat in a windowless room in a building without a public address. The room was cold. The monitors were blue. The coffee was the same burnt institutional blend it had been for 16 years. I was reviewing asset reports from a region I will never name, preparing a briefing that would be read by people I would never meet, about threats that the people of Millhaven, Tennessee, would never know existed. Mara was at home, in our apartment, not Diane's house, not Harlan's supervision. Our home. She was doing her homework at the kitchen table, and Midge Thornton was downstairs in her own unit, available if needed, never intrusive. On my desk, beside the encrypted terminal, there was a folded piece of notebook paper, creased into thirds, carried in a 12-year-old's pocket for 7 months. I had read it that first night, in a hotel room in Millhaven, after the courthouse and the parking lot, and the drive to the only place in town where no one would look for me. I read it once. Then I read it again. Then I folded it back along its creases and placed it in the inside pocket of my jacket, where it stayed until I returned to Washington. The letter didn't ask where I'd been. It didn't ask what I did. It didn't ask me to explain. It said, "I know you're doing something that matters. Come home when you can." Silence had been the language of my life. My father used it as evidence. My sister used it as distance. My mother endured it like weather. Mara understood it. She understood that silence isn't the absence of truth. It is the discipline of carrying truth in a world that isn't cleared to receive it. I work in a building with no name now. Same work, same coffee, same blue light. No plaques on the wall. No framed commendations in the hallway. Just Seren. Just the gray pin on my lapel, and a daughter who writes letters she knows I'll eventually read. There is power in patience. There is freedom in truth, even when it comes late. Even when it arrives in a sealed envelope that a family court judge will never be permitted to reproduce. Even when the people who should have believed you needed a federal affidavit to do it. I am no longer the blank space in the family narrative. I am the classified chapter, and some chapters are worth more sealed than open. If you enjoyed this story about quiet competence winning over loud arrogance, hit that like button and let me know what you think in the comments. And if you haven't subscribed yet, make sure to subscribe and ring that notification bell for more stories just like this one. Thanks for watching.